back to the show. This is The Law Show on CL 650.
Yes, famous music. You're listening to The Law Show here on CL 650. I'm Zach Spencer, and joining me in studio, personal injury lawyers Scott Stanley and Kevin Gourlay from MurphyBattista. We haven't touched on the WCB, Workers' Compensation Board, because anybody that's in a workplace and they have something happen, they fall under a different set of rules than you would outside of the workplace. How does it differ?
So if you are injured in the course of employment and there isn't an outside person responsible who wasn't working at the time, the law prohibits you from bringing a negligence case. You have to go under the WCB system where there are defined benefits and you don't have really any legal recourse to challenge what you're entitled to and whether you're entitled to it.
I'll give you an example. Say you worked in a building that wasn't constructed properly and part of the building collapsed and you were injured. So is that under workers' compensation, or would you have recourse because of the contractor who built the building didn't build it to the proper code? How would that one work?
It could be a bit of both.
Yeah.
It most likely would be WCB, I would think, in most cases.
And oftentimes there's a big fight over that, whether or not this was in the course of employment. I had a matter I was helping somebody out with recently where he was working up in the Queen Charlotte Islands, and he has to drive 2 hours and then take a 45-minute boat ride to get to his forestry job every day. And typically your usual commute doesn't fall within WCB coverage.
Right.
If I'm just driving to my job in the morning, my job doesn't start until I get there in the morning. Mm-hmm. But sometimes in an exceptional circumstance, that commute can be considered part of the job. Here, we wanted him to have WCB coverage. He went off the road and was very badly injured, but it was his own fault. There was no negligence claim. And WCB said that it was part of a regular commute, even though it was two hours and then a boat ride to get to the block. And so we had to fight that to make sure that he did fall within the WCB scheme, so at least he had the access to some benefits. Having said that, the benefits that he would have access to are very minimal and far less than what he would be entitled to if, for example, he had suffered the same injuries as a result of somebody else's negligence.
All right, let's get to the core of what you guys do in many cases, which is injury around a car accident. You have two people, one guy's driving for FedEx, the other guy's driving for Purolator, and they get into an accident. Well, they're both on the work site in a vehicle. How does that impact what happens if there's somebody's badly injured?
So those two in that circumstance typically can't bring a negligence claim against whoever the responsible party is. But that's not set in stone. For example, if that FedEx driver was not going to his next delivery but was going to meet a friend for lunch and was leaving his typical route so that he could go have lunch, that might then fall outside of the workers' compensation scheme. So oftentimes we are dealing with what's called the Workers' Compensation Appeal Tribunal, who will make a decision about whether or not the individuals injured were working at the time, and also whether the individual who injured them was working at the time.
So are you telling me that the amounts that you get under workers' compensation are less than you would have an opportunity to in a regular civil case?
Much less. Injured workers don't get money for pain and suffering, and the money they get for future wage loss, it's usually a pension. It's usually not their actual wage loss. It's a pension. And the money they get for future care or medical expenses is usually quite limited. WCB is designed, in theory, and in theory, it's good. Anything that doesn't involve lawyers is a good thing.
Another lawyer joke. That's two today.
But so in theory, it's a system where people can go and get assistance when they're injured.
To get themselves back on their feet, right?
To get themselves back on their feet, get rehabilitated. And, I mean, WCB does some really good work to get people back to work. I can say that firsthand. I've seen that. But the people that don't get back to work, the people that have these complicated injuries that are somewhat controversial, like brain injuries or chronic pain, I can't say they're fairly treated by WCB. The people that go through WCB, they're usually not represented by lawyers because it's difficult to secure retainers. A lot of lawyers, ourselves included, don't have tremendous expertise dealing with WCB issues.
So there's a bit of a gray area?
Well, it's a bit of a difficult area where, I mean, lawyers haven't built up the capital, the human capital to represent people adequately in WCB. There's 3 or 4 in the province that I think are really good, but there's not a lot of lawyers that do it because there's not a lot of cases that are economically viable to retain a lawyer.
Mm-hmm.
And so
you're just saying the amounts aren't big enough that it's lawyers want to take it on.
Correct. Yeah.
Okay. Now, what about waivers? We're going back to waivers, and when it involves a car. So you have a different set of rules, I'm guessing. We talked about waivers earlier and how you, especially this alligator story in Disney, if it was in Canada, if you had signed a waiver or gone through the park gate with the ticket, you don't have a recourse. So is there anything about cars where waivers are different?
Well, not in the legislation itself, but there was a decision not long ago that went to our Court of Appeal where somebody had gone on I believe it was also a ziplining activity, signed up for it, and then got on the ziplining company's bus and got in an accident on the way to the facility. And the ziplining company tried to rely on their waiver to say that they couldn't be sued for the injuries they caused. And the Court of Appeal said that given the fact that we have a mandatory liability insurance scheme in British Columbia, all motor vehicle drivers have to be insured, that it would be contrary to public policy to allow drivers to exclude liability with a waiver in the motor vehicle context.
So that seems discriminatory. You can have it in because it affects ICBC, but not for all of these other things.
You could certainly make that argument.
So you can't get your passengers to sign a waivers act before you take them for a ride in all these new cars you're tooling around.
Yeah, well, this is the thing. I mean, I think I'm going to get a waiver for anybody that enters my property. They get the mailman every day to sign the waiver.
You could. I mean, what's really unfair about waivers?
Sorry, letter carrier. I shouldn't say mailman. Yeah,
letter carrier.
He is mail, though.
There you go. I mean, what's really I find fundamentally unfair about waivers? I mean, if you take skiing, and let's look at Whistler Blackcomb. That's a really safe place to go and have fun. And
world class.
World class, and really a world leader. And I think everybody understands the risks associated with skiing. Most people have it's a graduated ski. If you're not a great skier, you go on the bunny hill, green, blue, and then maybe a black. So it's a pretty safe experience. What is different, and I'll give you an example. My wife and I years ago, kids were with my mom and dad, and we thought, let's go snorkeling out in Molokai. And signed the waiver, and they said, well, one of the risks are you could get jellyfish and this and that, but one of the risks is you could get bit by a shark. Well, anybody that saw Jaws realizes that's an absolutely terrifying prospect.
Yes, it ruined my swimming for my whole life, really.
And this new movie, The Shallows, that I can't wait to see.
No, I'm not going to see that.
Terrorize the next generation. But that's utterly terrifying. But yet I signed that thinking, what are the risks of me being bitten by a shark? I signed it, no problem. But if someone told...
Did your wife?
She signed it as well.
Did she ask for your legal advice on that?
She can swim quicker than I, so she can outswim me. But I would not have signed that if someone said, look, Mr. Stanley, there's actually been a shark bite 7 out of the last 10 times we've been out there. I wouldn't have signed it. And that's what we see. There's a lot of these activities are very risky. The risks are really only known to the operators. They don't tell people, so I don't think that's a fair deal.
Mm-hmm. It's like back to your bungee jumping. We've only had 6 cords snapped this week.
Exactly.
And by the way, you're number 7.
Exactly.
Do you still want to go? Yeah. All right. So your final thoughts, the whole theme of the show this time around has been the law and what we feel to be just can be 2 different things. So what are your final thoughts?
Well, if any of the listeners out there think anything we've said is intelligent and makes any sense, phone somebody, blog about it, phone your MLA, complain about it.
Well, it's been a real eye-opener, and that's why I love doing the show, because I always learn so much. But this one is a real eye-opener that we don't have any recourse for a lot of these activities we do. Even if we don't sign the waiver, there's no way to get to these people that run maybe operations that aren't on the up and up. Anything else?
I'd go back to the famous quote about democracy. I think it applies to our legal system too. It's an imperfect system, but it's the best one we've got, or a paraphrase of that.
Yeah, absolutely. Well, my guests today have been Scott Stanley and Kevin Gourlay from MurphyBattista in downtown Vancouver. Now, Scott's wife is a faster swimmer than him. We've learned that. It's great having you gentlemen on. Thank you very much for being here on CL 650, and we'll speak to you next time on The Law Show.
Thank you.
Thank you.